I hope all of you, your families, and your teams are doing well. So the topic for today's webinar is Decoding Press Note 3 and the revised NDI rules, that is the non-debt instruments rules. I'm sure most of you have had the opportunity to study these amendments and this rule and the press note. And keeping that in mind, our endeavor is to ensure that we give you some more sort of behind the scene or go beyond the text and address the issues that that will be in the coming months will come up regarding investments from neighboring countries of India. So some housekeeping announcements. I will take the questions right at the end after three of my colleagues have spoken. And I will, because it's a webinar, I will periodically have to ask my colleague to change the slide. So the webinar is broadly divided into 3 sections. One is the impact on fundraising, on M&A and PE deals, the impact on the press note and the rules, the interpretation of beneficial ownership, and impact on acquisition of companies. These 3 sections will be taken up respectively by Rohitashwa Prasad. Rohitashwa is part of our corporate and capital market practice of the firm. He specializes in M&A and PE transactions with a particular focus on listed companies. This will be followed by Lalit, providing an overview of the concept of beneficial ownership in the context of these changes. Lalit is part of the corporate practice of the firm. He specializes in corporate and commercial transactions like M&A, joint ventures, and private equity. Raj will be coming in to speak about the impact on acquisitions of overseas companies. Raj is based out of our Bangalore office. He's also a part of the corporate practice naturally because this really impacts our corporate practice. He specializes in offshore and M&A, offshore and onshore M&A and PE transactions, covering both FDI and ODI. So moving on now, Lalit. The slide after this. Thank you. So the press note 3 was issued on 17th of April, and it came into effect on 22nd of April because that's when the NID rules were amended. And the question that one needs to ask is that what has changed from April 22nd, 2020? Quite clearly, what the government has done is that it has said that all countries, investments coming from all countries which share a land border with India will require prior approval of the government. And this encompasses even sectors which are under automatic route and did not require the government approval route. Interestingly, obviously, since it relates to landlocked countries, Sri Lanka is not covered by this notification. 7 countries are in total. So that's Pakistan, Bangladesh, China, Nepal, Bhutan, Myanmar, and Afghanistan. Whether the investment is coming from China or the beneficial owner is situated in China or is a citizen of any of these countries. I mean, I'm saying China, but sorry, I'll come to that. But it is situated in any of these countries, the government approval will be required. So moving on, Lalit, can you change the slide? So the question is that while the government has, issued a statement that it's not targeting China, the language is that it applies to investments coming from all these countries which share land borders with India. What is interesting is that even before this change came about, even before 17th of April or 22nd of April, Bangladesh and Pakistan were both covered. So any investments from these countries did require an approval. So what has happened is, and it's important to understand the global context of it, what has happened is that with COVID-19, many people have said that it has actually sounded the death knell for the concept of globalization. The flat world is very, very quickly becoming a boxed world, with each country taking certain protectionist measures. So, any takeovers or acquisitions will globally, which affect or impact any country's sovereignty or security, will be looked at carefully. Thierry Bregton of the European Union, European Commission for International Markets and Services, has commented that Europe needs to rethink its industrial policy in the post-globalization era. Various member states of the European Union have been asked to make full use of the tools available to them to prevent capital flows from non-EU countries if such capital flows could undermine the security and public order of these countries. Spain, Germany, Italy, France have all announced measures for screening investments. How US will be using CFIUS is, up for debate. Australia has also come up with, certain conditions where certain types of takeovers and acquisitions would require prior approval. And so in this background, the natural conclusion is that the amendments are really aimed at investments coming from China. And why am I saying that is a natural conclusion is because if you look at the data, the investments there have been absolutely negligible investments which have come in from Pakistan or Bangladesh in the past several years. What is interesting is that China, while in our neighboring countries, has focused on investments in infrastructure and assets, so such as the Hambantota port in Sri Lanka or the Belt and Road Initiative, that part of it which falls within Pakistan. In India, the focus has been really the technology companies. So according to a Feb 2020 report, Chinese tech investors have invested $4 billion in Indian tech startups. 18 of the 30 Indian unicorns are now Chinese funded. While definitive statistics are not available on Chinese investments into India, because several of them come through different routes, could come through Singapore, etc. The range is between 8 billion, which is roughly what the Chinese figures are, the official figures are, to 26 billion, as per the Brookings Institute, Institute's report. So the question is that if you look at the press note 3, the government clearly set out its objective as being to curb opportunistic takeovers and acquisitions of Indian companies due to the COVID pandemic. And this sort of came very soon after, after the small stake purchase by People's Bank of China into HDFC. However, it seems that the government has not, or maybe it has thought through, and we don't know that it has thought through. The government, at least from people who are like ourselves, who are responsible many times for interpreting these regulations and for seeing that our clients implement them, it seems to us that there is a lack of clarity on certain areas as far as this notification and the press note are concerned. Lalit, can you change the slide, please? Thank you. Generally, I would say that since the government interpretation has, the stated objective in the press note 3, which talked about these opportunistic takeovers and acquisitions, has not been anywhere reflected in the NDI rules, we will need to take a stricter interpretation of the language of the press note and the rules. The government clearly, as I said earlier, needs to clarify the ambiguity. There may be a need to provide for some fast track approval route. What is clear to us is that it is prospective and not retrospective. It applies to primary and secondary investments both. Lalit, can you change the slide? And while there are different routes, no, the one before this. Yes, right, that's correct. So while there are different routes of investments into India, such as FDI, FPI, FVCI, based on what you'll hear from my colleagues, it seems to be clear that it's really applicable to FDI. Some of the exemptions which were earlier available for investments coming through FDI, including investments up to 5,000 crores, as long as the permitted shareholding did not change. That exemption also, it seems, is not going to apply. So moving on from there, I will now request Rohit Ashwa to take us through the impact on M&A and private equity investments.
Yeah, hi. Thank you very much, Shivpriya. Good afternoon, all. So, I'll just give you some of the, I'll talk about some of the practical implications that arise as a result of these amendments. So, Lalit, you can start with the. So, at the very outset, what I would like to point out is that although the amendments to the FDI policy cover all investments from China, but the amendments to the NDI rules, which give effect to the FDI policy, only amend Rule 6A, which covers FDI, foreign direct investments, whereas foreign portfolio investments, which comprises of investments by a SEBI registered foreign portfolio investor in a listed company of up to 10%, by a solo investor and its affiliates, and up to 24% in the aggregate, that continues to be under the automatic route. In addition to this, being a clear gap between what the FDI policy provides and what the NDI rules have translated this into, this distinction is going to have very different implications for listed companies as compared to unlisted companies in their fundraising efforts and also the transactions impacting them, which I will explain as I go along. So in the next few slides, I will deal with some questions that have already started coming to us from our clients, which also illustrate, in a sense, how the drafting of the amendments to these rules, the NDI rules in particular, has gone beyond the stated objective, that is of curbing opportunistic control transactions, and also the ambiguities and the unintended consequences that these will result in, which the government apparently has failed to contemplate. So if you can move to the next slide, Lalit. Yeah, Lalit, can you?
One moment, Rohit Ashwa. There's some glitch. Please pardon me. I'll move it. Just one moment, please. Rohit Ashwa, can you see that?
Yeah, I think you have moved. Yeah. This is.
I'm sorry. Apologies for this technical glitch. Carry on, Rohit Ashwa.
No problem. No, thank you. Thanks for your efforts, Lalit. So, one of the very first questions that arises is whether additional investments by existing Chinese investors without that resulting in acquisition of control are exempted or not. Unfortunately, the answer to this question is no, because although the amendments apply with prospective effect, yet any investment, even by existing investors, even under the current scheme of the FDI policy, it must comply with the policy and also the NDI rules, which are in effect at the time of the actual investment, which including the rules relating to pricing guidelines and sectoral caps. Therefore, all further rounds of investments by an existing Chinese investor in an investee company, whether or not such investment results in the acquisition of control of that company, will require governmental approval. For example, if a Chinese company were to increase its investment in its existing joint venture company, let's say from 30% to 40%, without getting any additional rights, that still will require government approval. Indeed, even the exercise of preemptive rights by a Chinese investor in the context of a fundraising, let's say, by the company, just in order to maintain the investor's level of shareholding, will require approval. So these are the implications that the government has not thought through. And the problem is if you, yeah. And so now coming to point number 3, when we see that the problem is compounded when we examine the other modes of fundraising, which may not be opportunistic at all and might not lead to a change in the shareholding of an existing investor or even in the capital structure of the company. Let's take the example of a rights issue where no renunciation is made. These are covered in Rule 7 of the NDI rules and have a uniform application irrespective of the mode of investment by the foreign investor. That is, they apply to FDI as well as FPI investments uniformly. And since only the FDI regulations have been changed and not the FPI, any subscription by an existing FDI investor, even to the extent of his rights, will require governmental approval. And the absurdity of the situation becomes all the more apparent when we consider funding routes which necessarily will not lead to any such changes. At least with the rights issue, one can contemplate a situation where an Indian investor renounces his right and a Chinese investor can potentially increase his level of shareholding. But something like that will never happen in the case of a bonus issue or, for that matter, a further investment into a wholly owned subsidiary. Or let's take the example of a payment of unpaid capital and partly paid shares. All of these now come within the ambit of governmental approval route. Then again, to take another example, if a Chinese investor held warrants on which he had already paid 25% upfront before April 22nd, 2020, and thereafter in exercise of his pre-existing right, wishes to convert those into equity shares by paying the balance 75%, that too will require approval, even though that is not changing the capital structure per se of the company. One really doubts if the government itself seeks to control such transactions. The government, in our view, urgently needs to lift these roadblocks by formally clarifying that these transactions do not require its approval. But pending the clarifications, unfortunately, one will necessarily have to apply for approval. Of course, it always is open for a particular investor or an investee company to explain to the government in the application process, in the approval process, that why in a particular case the investment is not going to result in an opportunistic acquisition or a takeover. But that argument now has to be made before the government. No company or investor can on its own suo moto come to that conclusion. Now, we take let's examine how the secondary transactions will be impacted. Any purchase of shares in an Indian company by a Chinese investor under the FDI route will require approval, irrespective of the percentage of shares acquired. Indeed, a sale by an existing Chinese investor to another Chinese investor without there being an increase in the overall investments from China in that company will also require approval. Similarly, even a group restructuring where shares are transferred by an existing Chinese investor to another member of its group has now come within the purview of the amendments. So all transactions, even when sought to be done as part of an exercise of a right which might have already accrued under an agreement existing prior to April 22, will require approval. So there is no grandfathering of existing agreements. For example, let's see a Chinese investor having a call option in its favor under a shareholders agreement. And let's say all the circumstances relating to the exercise of the call option have triggered. And the investor decides to exercise his call option subsequently. Or even if he has already exercised the call option, but the transfer has not taken place. For example, if people are debating and discussing the valuation relative to what the call option price is, that will require approval. That can't be done now under the automatic route. Similarly, if there is a put option, even against a Chinese investor, that will require approval, even notwithstanding that a put option in such a case results in a forced acquisition and is not opportunistic, at least for the purchaser. So the extent to which there is no grandfathering can also be seen from a rights issue or a bonus issue. If all the procedure, for example, has been completed by the company prior to coming into the amendments, and all that needs to be done is the actual subscription and the issuance, it cannot be done in favor of a Chinese company unless the government has approved it. Now, since there's one particular aspect that I'll deal with and would like to highlight is that of how private equity and VC investments are going to impact it. And that becomes a very topical issue because a significant amount of investments in Indian companies from China has been invested by PE and VC investors. So any investment that comes from a PE or a VC fund which is owned and or controlled by Chinese citizens or residents will require approval now. It is important to note that it is the residency status of the LPs of the fund that is determinative, and the concept of ownership here is synonymous with that of beneficial ownership, not significant beneficial ownership, as in the Companies Act, which my partner Lalit is going to talk to you in detail. Now, one particular kind of fund vehicle that is, however, accepted from approval is an AIF, which is an alternative investment fund, which is covered in Rule 6C of the NDI rules, read with Schedule 8. If the sponsor, manager, and investment manager of a AIF is either an Indian citizen, resident, or an Indian owned or controlled entity, then it can make downstream investments into Indian companies, even if it has investments from Chinese investors. Now, one very important thing that can be lost sight of is that it is that FPI, foreign portfolio investments, are an exception. Any fundraising, whether by way of a fresh standalone investment or a rights issue or a bonus issue that we talked about, all the modes of investment, or even a secondary purchase, in any case by a SEBI registered FPI of up to 10% in a listed company will not require any approval. The assumption of the government seems to be that since these investments are limited to 10% by a single FPI and 24% in the aggregate, they would not lead to a controlled transaction. Well, given the shareholding patterns of a typical listed Indian company, this may hold true for a large majority of them. And herein lies the irony of the situation. The conventional wisdom, as Shipriya was talking about, is that these amendments were prompted by the People's Bank of China's open market purchase of an insignificant holding in HDFC, but the amendments have covered only FDI, not FPI. The government must therefore recognize that its amendments are painted with the same brush all forms of fundraising by unlisted companies. I'm sure, the government is not blind to the vested interest that the Chinese investors have in India and the importance of China as a source of continued funding for Indian companies. It is estimated that there are more than 800 Chinese investee companies in India in a wide range of sectors, some of which Shipriya talked about. In the startup sector, China is the source of $4 billion worth of funding, $4 billion worth of funding. All of these companies are at stages of growth or in sectors which it is not difficult to anticipate will need critical and speedy funding to survive COVID-19. The government therefore must move fast to clear these ambiguities. Alternatively, if it still wants to have a say at least, and by the way, that is important, the fresh investments are not prohibited. All that the government is saying is that please come to me for approval. And so in that case, the government must set up a dedicated fast track mechanism for examining and approving such transactions without undue delay. Lalit, you can move it.
Good evening, everyone, and thank you for joining. Thank you, Rohitashwa. Thank you, Shipriya, for a nice opening session and remark on a very, very important concept. I will cover the aspects related to beneficial ownership. Now, according to me, this is the most important and yet the most ambiguous provision of all these amendments. There are many more problems and concerns here, but in my view, the concept of beneficial ownership is very, very important. And why I say that? Because if you see both press note number 3 and the NDI rules, they apply when beneficial owner of foreign investments into India is either situated in one of these neighboring countries, maybe our particular focus is say China, or is a citizen of these countries, say China, whether through a primary investment, which means that the entity situated in that jurisdiction or the citizen situated in that based out of that jurisdiction infuses FDI, or through a secondary acquisition, which means that there is already an Indian entity or there is already a foreign investor other than the jurisdiction which are restricted. An entity from China or a citizen based out of China goes and acquires the shares of that entity through a secondary acquisition, these amendments trigger. Now, because everything is based on the concept of beneficial ownership, so it becomes very, very important to understand what is beneficial ownership and when does it trigger. And I said ambiguous because it is neither defined in the FDI policy nor in the NDI rules. So we felt that such an important concept, as Shripriya earlier said, that 17th April, this press note came. Everyone wanted to hear from the government that what are the various interpretations of beneficial ownership and other concepts as well, wherever there is any concern. So everyone waited for the NDI rules to come in. They did come 22nd April, everything is in force now. There is no guidance, there is no clarity yet. So therefore, we are not clear that what will be the concept of beneficial ownership as far as these amendments are concerned. So whatever is available, legal literature and provisions in statutes and regulations are available, we're trying to figure out which will fit the bill best here. So as I said, not only the primary and secondary, also the concept becomes very important because both press note 3 and the NDI rules say acquisition, which is direct or indirect, which means you could directly acquire the beneficial ownership or you could indirectly acquire the beneficial ownership. But the crux is, and the rule is around whether or not you acquired beneficial ownership or not. So therefore, it becomes very important to understand what is this concept. Now, generally as lawyers, what we do, whenever there is a term which is not defined in our statute, we go to the generic definition, which is what we did when we were analyzing the NDI rules to see, is there any definition of this term? We didn't find, and there is none. But there is a generic concept which says that if any term is not defined in the FDI policy and the NDI rules, you can look into FEMA, the Foreign Exchange Management Act, and its related rules and regulation. We did that. And when we saw that even FEMA does not have, that is an irony, the FEMA also does not have any definition of beneficial ownership. Now, if left to lawyers like us and people like you have all the right to frame your own possible interpretations because of these poor drafting. So you could take a very liberal interpretation or a strict interpretation, and I cannot say that our interpretation will be better than yours or yours will be better than mine because there is complete ambiguity as we talk right now. But we can't leave it to ambiguity, we have to take views. So therefore, there's another exercise which we carried out to find out that is this term beneficially owned, beneficial ownership or related concepts, have they been used anywhere in the FDI policy or the NDI rules? And the answer is yes, we did find, though not in the context of press note 3 and the NDI rules because they are new, but we did find that there are few instances in the FDI policies and also in the NDI rules where this concept of beneficial ownership and beneficially owned and beneficial interest has been used. Let me take one or two examples to emphasize this point. See, when we calculate the investment by the Indian citizens or Indian companies, as you know, FDI is the foreign investment, but remaining part is held by Indian entities or Indian citizens or companies which are controlled by Indian citizens. In the context of deciding whether the Indian entity and Indian citizen hold that company, there is a definition of the term owned, which is what is there in the slide before you. So what it says, a company is considered as owned by resident Indian citizens if more than 50% of the capital is beneficially owned. So therefore, the emphasis is that there is an expression used beneficially owned. and it says by resident Indian citizens or Indian companies which are ultimately owned and controlled by resident Indian citizens. So there is a concept. The question is, nobody had raised this issue so far. This is not the first time that we are using this expression in the FDI policy and the NDI rules. Similarly, there is another example when we calculate sectoral caps. So there is FDI cap, and then whatever is not held by the foreign investor is held by the Indian investor or the Indian party. So when we calculate the sectoral caps, so there is a guidance in the FDI policy which says that when you calculate the remaining equity, which means the equity beyond the foreign cap, which is the one which is held by the Indian side, it will mean what is beneficially owned and or held in the hands of Indian citizens and Indian companies and owned and controlled by Indian citizens. There too is a definition, not the definition, beg your pardon, but there is an expression which says beneficially owned. So what is it that I'm trying to say here is that both the FDI policy and the NDI rules have these expressions. But what is the fuss now? Because everyone seems to be having different views and different arguments, discussions, debates, and it's good because we'll get to something eventually what it means. But what is the fuss now? What is the problem now? Why is suddenly has become of great importance? The reason being that unlike the places where this concept has been used in the FDI policy, now entire thing rests on this concept as far as Press Note 3 is concerned and the NDI rules is concerned. So therefore, everyone wants clarity. I mean, as lawyers also, we want clarity that what does it mean? So therefore, it has assumed great significance because if the beneficial ownership of the shares is not even held by citizens and entities situated in one of these 7 countries, then we don't have to go and take any approval. So therefore, it's very important to understand what is this all about. So how will this guessing game end, right? So let's see, there is ambiguity. Nobody is denying this fact. So therefore, what should one look at? It's not that there is no guidance, there is no literature that we can rely upon. In this context, let me bring to your attention the concepts used in the Companies Act and the Reserve Bank of India Know Your Customer KYC directions of 2016. Let's talk about Companies Act first. See, Companies Act has 2 concepts. One is the concept of holding beneficial interest. Mind you, that is not beneficial ownership in the expression. It's not called beneficial ownership, but I'll just discuss and tell you that how it can mean the same thing as beneficial owner. But the actual term which is used in the Companies Act is holder of beneficial interest. And the other concept is significant beneficial owner. They look similar. They are defined, in fact, similarly, but they have a very stark difference, which I'll tell you in a little while. So therefore, beneficial interest means there is a definition in section 89 of the Companies Act, and I've put that before on this slide before you. So what it says is beneficial interest in a share includes directly or indirectly, whether through any contract, any arrangement, or any other manner, the use of the expression otherwise written there, leading to what? Leading to right or entitlement of a person, either alone or together with other persons, to do something and over the Indian company, and which is exercise or cause to be exercised any on all of the rights attached to such shares, or right to receive or participate in dividend or other distributions in respect of such shares. So there is a concept of beneficial interest, which means that if there is any person, either alone or jointly with anyone else, either through a written contract or through an arrangement or in any other manner, gets a right, and right is such, or that entitlement is such that the person is able to exercise or cause to exercise rights over the shares, which means the shares of the Indian company. So if such is the right a person has, it can be said that that person was the beneficial owner because he had the beneficial interest on in those shares. Therefore, when we look at the definition in the Companies Act, it looks like, as Shipriya said and Rohitashva also reiterated, that there is no clarity. But as the things appear now, looks like that this is a good definition. That is what the government wanted to, strictly interpret it. And we are not able to give a very liberal interpretation to this. So therefore, looks like that if anyone is holding these rights over an Indian company, will be said to be holding the beneficial interest and consequently will be the beneficial owner for those shares. Let me also share with you a concept of significant beneficial owner. See, significant beneficial owner is a more liberal concept, and one will be tempted to even apply this concept. Why I say this is liberal concept? Because if you see the SBO rules, there are rules under the Companies Act called the SBO rules. In those rules, as the name suggests, that the owner has to be a significant shareholder, and there is a limit, a starting limit or starting point in those rules is someone who holds at least 10% of the shares or the voting rights. Now, if we take this, and they are very, very comprehensively written rules, right? We can take those as basis for our interpretation, but we feel that that may not be the intention, because the starting point is 10%, which means that the entity must first hold 10% in the Indian company, and only then, if that entity is eventually beneficially owned by citizens and entities of the restricted countries, including China, then only this press note and NDI rules will apply. We don't think that that should be the intention, because it starts with 10% shares of the Indian entity. So although it is liberal, but we think that this may not be the intention of the government, and can be ignored. Then looking at the KYC directions, if you see the KYC's direction, so many are tempted, including we have also examined several times on this issue, that KYC norms are given by Reserve Bank of India, adopted by the government, and they are KYC norm for their bankers' customers. Now there also the concept of beneficial ownership is there, and it depends upon who the customer is. If the customer is a company, then there is a different rule. If the customer is a partnership, association, or body of individuals or trust, it is a different rule. But the important point there is that there also, in case of company, for example, it is only when a person is said to be a beneficial owner, only when the controlling ownership interest, which is defined at 25%, is held. Similarly, in the case of partnership and unincorporated association or body of individuals or trust, it is at 15%. Again, just like the SBO rules, the starting point here is 25% or 15% respectively, depending upon the nature of the entity. Here also we felt that possibly that is not the intention of these amendments, and therefore these two concepts of SBO and KYC may not be appropriately, or cannot be appropriately used for the purposes of determining beneficial ownership. So where do we stand now? I mean, with everything not very clear, so there will always be room for interpretation. People will interpret the concept of beneficial interest and beneficial ownership differently. But we feel that until the clarification is issued by the government in this aspect, it will be fair, correct, and most appropriate to go and use the concept of beneficial interest, which is under the Companies Act. Let me quickly take one example so that I can explain how it can be determined. Let's assume a case of an SPV, special purpose vehicle, which holds shares in the Indian company. That SPV is held, say, 5% by an investor in China. And by holding that 5%, maybe through the SPV, that 5% shareholder may not be able to control the rights, may not be able to have entitlement over the rights on Indian shares. It could be argued that he did not hold the beneficial ownership of the equivalent to that 5% shares in the Indian entity, and a view could be taken that he did not beneficially own the Indian company, and therefore these rules will not apply. On the contrary, suppose the same SPV is held 50% by the investor from China. Possibly then to say that with 50% in the SPV, that investor did not indirectly have beneficial interest in the context of the Companies Act that we just discussed, could be difficult to explain and could be difficult to convince. So in the two situations, maybe in a 5% acquisition with no right over the Indian company, one could possibly take a view that there is no acquisition of beneficial ownership and therefore this press note will not apply. But maybe with 50% acquisition, the press note and these new rules will apply. So lastly, because there is some room for interpretation, especially when we have to do indirect investments. For direct investment, the FDI comes directly into the company. There is no room for interpretation. But if the investment is coming indirectly, and where there is some discussion or some issues to be resolved regarding whether or not the beneficial ownership was with a person of these countries, there is some room of interpretation by using not only the ambiguity, but even the subjective rule and subjective definition given in the Companies Act. So what we urge you all to look at is there's no straight jacket formula for this. It will depend upon the facts and the circumstances, the investment agreements, the deal, and everything related to it. And if the conclusion is that the person did hold the beneficial ownership, then as Rohitashwa said, it's not barred, it's not prohibited. The government needs to know and approve that, and there's no other way than to go to the government and seek approval for that investment. Thank you very much. Now I will ask my partner Raj. He will cover the topic of impact on acquisition of overseas companies. Over to you, Raj.
Yeah, thank you, Lalit. I will cover the topic on overseas acquisitions. Thank you, participants, for joining in. We have already covered an overview of the changes, the impact to fundraising as well as M&A PE deals, and how beneficial interest and ownership is to be interpreted. The other key aspect, as Lalit mentioned, which is contemplated in Press Note 3 of 2020 that I'm covering in this session, is the impact of acquisition of overseas entities, that is entities based out of a non-India jurisdiction but having a stake in an Indian company. Since the press note intends to cover any acquisition in India with particular reference to beneficial ownership, in addition to restricting direct acquisitions in Indian companies, both primary and secondary, what also had to be covered was acquisitions of foreign companies. The reason is, as we all understand, acquisition of a foreign company having interest in an Indian company would be akin to acquiring stake in an Indian company. So how is it sought to be regulated by Press Note 3? It is specified in Press Note 3 that any direct or indirect acquisitions will be covered. Many times when we're involved in India-led transactions of global acquisitions, the structure is of an offshore acquirer acquiring the shares of an offshore target having a subsidiary in India. Now, all such transactions will require to be examined if they will be under the automatic route or whether the approval route will be applicable if the beneficial owner is from a country that shares land border with India. This restriction on acquisition of overseas entities would apply, therefore, for transactions whether the target overseas entity is a privately held company or a publicly listed company, and irrespective of the stake that the overseas entity has in the Indian entity. The only distinction perhaps would be in the case of listed overseas companies, since the quantum of stake acquired as well as the rights attached to that stake would determine whether such an acquisition would be restricted or not. Let's look at listed overseas target entities first, which are in illustration A and illustration B. In illustration B and A, the reference to neighboring country entity would be the acquirer or the investor. The reference to the offshore entity listed would be the target entity outside India, and the reference to onshore entity would mean the underlying Indian company. The difference, if you notice, between illustration A and illustration B is that illustration A contemplates a transaction which is primary or secondary, but without any special rights, whereas illustration B contemplates a transaction with special rights. So for example, if in illustration A, if the acquisition is of say a nominal 1% stake in an overseas listed company, which in turn has a stake in an Indian company, such a transaction per se may not be the one that was sought to be regulated. However, if the stake acquisition in illustration B is say higher, about 10%, and there are special rights attached to those 10% stake in terms of affirmative votes or other management rights, such a transaction may be covered given the intention of the restriction that has been imposed. What are these special rights that we are discussing now? If these special rights are only in respect of the listed entity with no specific rights attached to the India entity itself, that would not constitute a transaction that is sought to be restricted. However, if the special rights permit the investor to have a substantial say in the India entity matters, that could be one transaction which is sought to be restricted. I can give you an example. Let's say dividends are declared by the India entity to the offshore listed entity. It is not necessary that the dividends that are declared are also declared onward to the acquirer from the dividends received from the Indian company. Where, however, the investor has the rights or the ability to require that the dividend received by the offshore listed company are received by it proportionately or otherwise, such a transaction will require to be examined more closely in terms of Press Note 3. Another important point to be borne in mind is that in a public listed company, the ability to have special rights covering the India entity would be more difficult and hence will require closer examination. Even say where there are hundreds of shareholders from China, for example, but they're all public nominal shareholders and only have the standard voting and dividend rights, those will not be considered as rights attached to the India entity requiring examination of the corporate wheel. However, if there is a large investor in the listed company and that investor has special rights that relate specifically to India, those could come under the scanner. Now, having examined listed entities, we can now look at acquisition of stake in offshore privately held companies, which are illustrated in C and D, where the acquisition of stake is in an overseas entity that is privately held. Irrespective of the stake acquired, the restriction would be applicable. If you look at illustration C and D, the reference to neighboring country entity again is the acquirer investor. The reference to offshore entity unlisted is the target company based outside of India. And the reference to onshore entity is the entity based in India, the underlying Indian entity. Illustration C covers secondary transactions and illustration D covers primary transactions, whether or not such primary transactions involve a remittance to India. All these cases would be within the restriction imposed by Press Note 3. The reason for this is that in privately held companies, the stakeholders can have inter se voting agreements. They could have other arrangements like non-disposal undertakings, NDUs, which may not be in the public domain. As we discussed previously, the ability to have rights would be far simpler in privately held companies than in public listed companies, and hence there's likely to be a presumption of such rights linked directly to the underlying Indian entity, where the acquired entity is a privately held company, even outside India. Another point relevant to take note of is the monitoring and the compliance mechanism. If we look at illustration C, for example, of a secondary transaction, here the India entity, the onshore entity, may not be able to exercise any control over the transaction between the two overseas entities. But here again, we're only dealing with one level shareholder. The ability to ascertain these may get more complex if there are multiple layers of shareholders and there being no change in the shareholding of the India entity, so as to be able to identify and report such transactions. So in illustration D, for example, if the neighboring country entity were to acquire shares in the parent of the offshore entity unlisted, that would also not trigger any actions by the underlying India entity. Illustration D also covers more situations and the provisions of Press Note 3 would apply. Here again, we could have two scenarios. One, where the funds are remitted to India after the fundraise at the offshore entity level, and two, where the funds are not remitted to India. In the first scenario, where the funds are remitted to India, which includes the funds raised by the offshore unlisted company from the acquirer or the investor, that would squarely come under Press Note 3. Even in the second scenario, where the fundraise is primary in nature, but the funds are not remitted to India, but used for global operations, the restriction under the Press Note would be applicable, since by acquiring a stake in the overseas entity, the beneficial interest in the underlying Indian entity is acquired, and that would also be covered within the ambit of the restriction imposed by the press note. In terms of gaps, there is no control mechanism that is exercisable over such overseas acquisitions. There is no reporting mechanism that is being stipulated in such cases. As discussed, the Indian entity may not even be able to restrict the transfer of shares where the share transfer occurs at a higher level of the corporate structure. Perhaps, therefore, an undertaking may require to be filed by the Indian company stating that there has been no breach of Press Note 3, which in turn will be based on undertakings and confirmations from its stakeholders, especially for entities having a corporate structure that has several layers of entities. As Lalit mentioned, it is important to note also that the SBO rules today only require disclosure and reporting for stakeholdings of 10% or more. All in all, it really remains to be seen how this will fully play out. What are the positions that the authorized dealer banks will take for various transactions having different corporate structures? What conditions are imposed by the government while granting approvals, so that there is some guidance to such transactions on a going forward basis. Thank you all for your time. Over to you, Shipriya.
Thank you everyone for patiently listening to us. We have received several questions and we have some time, so I'll try and cover as many questions as have been received. Just give me a minute. So some of the questions are, I don't know who's asked these questions. So the first question is for you, Rohitashwa. Assuming the initial investment from China was made before 2017, can this restriction lead to challenge under BIT, that's under the treaties?
Right. Well, my instinctive answer to this will be that no, this cannot lead to, or this will not be proper grounds, fundamental sound grounds for a challenge under BIT. The reason being that, look, there is no expropriation of existing investments. All that the government and nor is the government adding or enhancing the number of sectors with sectoral caps. All that the government is saying is that if there is an investment flowing into an Indian company from certain jurisdictions, which are the jurisdictions which neighbor India, then please come to me for approval. Please explain to me that your investment is not opportunistic, that you are not taking advantage of artificially and temporarily depressed prices on account of COVID-19. So if at all a larger policy level challenge that has to be made to this amendment, that is, in my view, subject matter of a WTO domain, which we have all heard is that there are murmurs that the Chinese government may be thinking of taking India to WTO, but not under a BIT, because the government can still say that, look, I am not expropriating any investments, and as and when proposals start coming to me, I will approve them depending upon the genuineness. So unless we, as an empirical matter, we start finding ourselves in a situation that the government is carte blanche, not granting approval to these applications, it is, in my view, difficult to take recourse to BIT to challenge this notification.
Okay. Thank you, Rohitashwa. The next question is also for you. It says, this is also, I don't know who's asked this question, how to exactly differentiate between FDI and FPI, given that now the extent of FPI has also been increased to sectoral caps?
Right. You see, an FPI by definition is an investment by a certain category of investor, which is a foreign portfolio investor, and he must be registered with SEBI. SEBI has its own process for approving the registration. Once you've done that, you open a demat account and you do trade on the stock exchanges. And FPI investments are only investments in listed companies. if an FPI invests in an unlisted company, that is FDI for all purposes. So that is where the distinction is. And even in those companies, where it is open up to the sectoral caps, you have to pass a resolution to increase the shareholding up to that level. So as a matter of procedure, there are enough structures in place to distinguish when a particular investment is FPI and when it is FDI.
Okay, thank you. The next question, Lalit, is closest to what you were covering, so I'll pass it on to you. This is from Ankit. The question is residency, meaning the country where person is residing, or tax residency?
This is a good question, Ankit. There is no clarity and there's nothing clearly given here, and not only in press note 3 and the NDI rules, even in the other FDI policy and NDI rules. So there's no clear defined concept of residencies test or citizenships test. I think the way this has been written right now, it looks like it has to be on the basis of the citizenship test, that whether or not the person was a citizen, resided, that's how the language looks like of the press note and the amended rule 6A, the provisos that have been inserted. So I think the view would be that it will mean the citizenship test over the tax residency test.
Okay, thank you. So Rohit Asha, here's an interesting question which we, internally discussed a lot about, and this relates to jurisdictions such as Taiwan, Hong Kong, and Macau. This question is also, just give me a minute. Yeah, so I don't know who's asked this question, but the question is, do we have a sense of whether Press Note 3 intends to cover Taiwan, Hong Kong, Macau as well?
Well, that's interesting. So that is a question which is very, very important and relevant, because especially in the context of a lot of investments into India being rooted out of PE and VC funds, which are managed where the management resides in, let's say, Hong Kong, but it may be beneficially owned by Chinese investors. So look, I think Hong Kong and Taiwan, I will distinguish between. So far as Hong Kong is concerned, the government of India for certain things has a special dispensation. For example, there is a separate tax treaty that India has with Hong Kong and a different one with China. If I'm not mistaken, Hong Kong is also part of one of the reciprocating territories under Section 44 of the CPC. But these are all special dispensations. So wherever the government has wanted to make exceptions for Hong Kong or has wanted to treat Hong Kong on a different footing than China, it has expressly specified so and has that special provision. Press Note 3 does not make that distinction. So therefore, our view is that unless a clarification comes, Hong Kong investments routed through Hong Kong are included within the ambit of the approval requirement. So far as Taiwan is concerned, Taiwan is in a sort of a unique political situation. So it claims a different sovereignty, but India has not gone ahead and ruffled Chinese feathers there. So our position, our view on the amendment is that to begin with, you have to, if you have to advise a client, or if you are a company thinking of investing in India and you are based in Taiwan, then one must at least go to the government for file an application for approval, and let's see what the government says.
Thanks. Also, Rohit Asha, just to add, the intent seems to be, as we've discussed through the webinar, the intent is to regulate Chinese investment. So clearly that's what probably will guide how, all of this is interpreted.
Yes, indeed.
So, okay. So the next question is for Raj. This question is from Arjun. In your view, do the new FDI rules also cover companies that have a holding company that is based in Singapore or Mauritius, and the Chinese investors invest in the holding entity?
Yeah, sure, I'll take that. So I think if the question I heard it right is that the Chinese investor would invest in the holding company, which is based out of Singapore.
Raj, let me repeat the question for you. In your view, do the new FDI rules also cover companies that have a holding company that is based in Singapore or Mauritius, and the Chinese investor invests in the holding entity? So there's an Indian company which has a holding company in Singapore or Mauritius, in which a Chinese investment comes in.
Yes, it would be fairly covered, where the Mauritius or the Singapore company has a stake in the Indian company, and the Chinese investor acquires a stake in that Singapore or Mauritius company. It would be akin to acquiring stake indirectly in the Indian company, and therefore, whether it is a secondary transaction or a primary transaction at the Mauritius or the Singapore level, it would get covered under the FDI rules. Because the intent behind this is to verify and confirm whether the beneficial owner, going all the way up of the Indian entity would be with a citizen of one of those countries which are neighboring to India. And that test will be satisfied in this.
Okay, Lalit, here's another one for you on beneficial ownership. So the question is really on, the logic of saying that, whenever there is a beneficial ownership, you need the approval. So the question is, and this is, I don't know who's asked because it's anonymous, do you mean this is irrespective of percentage when you say that it's better to go and get government approval if there is, a beneficial ownership? So, for example, if a natural person, citizen of and resident in China, holds 1% of the US entity, which is investing in an Indian company, would government approval be required? How far is it practical?
So my view is the example that has been given in that question. I don't think so that approval is required as far as that 1% shareholding is concerned. And the reason is, see, beneficial ownership does not mean that you just go up, look for someone, he holds, or any citizen, any entity holds 1%, 1 share, 10%, and just fix that person and say you needed approval. That's not how it works. In the example that has been given, the Chinese investor has 1% in the US entity. Now that US entity has independent investment in the Indian company. So the US entity could be listed or even unlisted. That does not make any distinction. But with that 1% share, suppose he wants to have rights over the Indian company shares to fulfill the test of beneficial interest. And even if we do not take the concept of beneficial interest and take even the liberal ones, for example, SBO rules, KYC norms of RBI, even there, through that 1% share, by no stretch of imagination, it can be proved that through the 1% shareholding in the US entity, the 1% Chinese investor was indirectly holding 1% of the Indian entity. Looks unlikely. But if through that 1% shareholding, he gets so much of rights, I don't know, that will be hypothetical, not practical, not real. If that person gets so much of right and says that whenever anything happens at the Indian entity level, I will vote and I will exercise my right for that 1% share of the Indian entity also. So indirectly through the US entity, he is starting to hold 1% of Indian entities' shares. If that is the case, which I feel will be unlikely in this example, I don't think so. In that case, any approval will be required. I think even Raj had made that distinction of acquiring a listed entity or an unlisted entity. So let's quickly take an example of a listed company in US, and there are say 400, 500 Chinese investors, both entities and individuals. They are holding shares of US listed entity. I mean, few shares, percentages, but their investment is in the listed entity in the US. Now the US entity in turn holds shares of any Indian company. They cannot through the listed entity start controlling Indian entity, or even the listed company would say that, look, you are just a mere public shareholder in the listed entity. we are not giving you any rights in the Indian entity. All the rights you have is in the US entity. On the contrary, if that 1% shareholding is made, say 51%, and the Chinese citizen becomes the promoter of the listed company, because of the change of fact, one could say, yes, through the holding of 51% share, that investor will get all the rights on the Indian assets also, which means the Indian shares. Then one possibly could say that he or she held the beneficial ownership and would require government approval. So in summary, in the question that was posed, I don't think so approval is required.
Okay, thank you, Lalit. Moving on to the next question. This is to Raj. Will approval be required for, again, anonymous? We have a number of anonymous questions. Will approval be required for a direct investment of 4.9% by a Chinese controlled VC into an Indian company?
Yes, I think it would require, and there's no minimum percentage threshold that has been prescribed under the rules to state that if the direct investment into India is up to a certain percentage, then those investment transactions are exempt. And absent those specific exemptions, we should proceed on the basis that any direct investment into India by a Chinese controlled VC fund would require approval if it's coming into India.
Yeah, and it's really, in that context, it's really the time for people to sort of get together and start approaching the government, saying some of these don't seem to be reasonable restrictions, and there is a need for clarifications. And in the same vein, again for Raj, in indirect overseas acquisitions with special rights, which party needs to seek an approval?
It would always be the party who would require to make the investment. So even that procedure is not clear now in the rules. But naturally, like in case of any FDI investment, it is always the investor who makes an approval application. So here again, it would be the acquirer investor who would have to go and seek the approval in order to be able to make the investment. Okay, and the next one is an interesting question, and I'll sort of it'll be interesting to have all your views. What would have been the impact of Press Note 3 had the amendment to NDI rules not been notified? Further, how would the ambiguities between the two be addressed? It's a very open-ended question. One thing that I can clearly say is that that whole clarification that we've given in terms of the FPI and non-applicability to that would have been sort of up in the air, but I would like to hear from the three of you if you have any additional comments to give.
Hi, Shipriya. So very good question, very general, but it goes to the root of the entire issue. And on 17th of April, when this press note came, I think we were all wondering, and waiting for NDI rules to be notified. So the question is that if NDI rules were not amended or not changed with effect from 22nd April, I think the press note doesn't have the legal backing to, so to say. It is the law, which is the NDI rules. And even the press note itself said that it will come into force when the FEMA notification comes, and quickly it came soon thereafter, after 4 to 5 days it came. So without the amendment in NDI rules, it would not have come into force. The interesting question that has been asked, and which I think Shipriya, you and Rohitashva later on also covered, that Press Note 3 has a subject line where it showed what the government intended to do. But in the fine print, even in the Press Note 3, when they amended 3.1.1a and b in the FDI policy and replaced it with a new provision, there is not a trace of that objective and intention mentioned there. So no matter how much purposive interpretation we would like to take, neither the government nor the NDI rules later on have left any room for that kind of interpretation. So therefore, yes, one could challenge, I mean, I'm not suggesting that, but one could challenge that the law is strict and the intention was different, and we have to read it liberally. But I'm not sure whether such kind of a challenge and issue will succeed, because the fine print is very, very clear. So yes, of course, everyone agrees there is some mismatch between the intention and what has come eventually in the fine print. I hope as I've answered, maybe Rohitashva, Raj, you would like to add something?
Would you?
I mean, and to some extent, it's a moot point now because of two reasons. First, the amendment has come into place. Secondly, now that the NDI rules are also within the within the remit of the government itself, unlike the TISPRO, which was under the remit of the RBI. So there is much more coordinated thing, and that is why within 3-4 days of that press note coming in, the NDI rules have also been amended. But as a matter of law, yes, unless the NDI rules are amended, the press notes are only statements of intent.
Okay, so the last question is for you, Rohitashwa. The question is, can holding of India Co exceed 25% by non-associate FPIs from China without FDI approval? Individual limit, and it says with the individual limit of 10% being maintained.
Yeah, very interesting, question. You see what? Let me start giving you the answer. The answer is yes. So let's say there is a listed company where the FPI limit through a resolution has been increased to the level of the sectoral limit in that particular industry. Then different FPIs from China can acquire up to 10% each and can theoretically go above 25% if there is enough headroom in that particular company's public float, and if that can be mopped up from the market. So that is not impossible. Indeed, let's take the example of HDFC. In HDFC, 70.88% of its shareholding is by FPIs, but that is an exceptional company, because most of the listed companies in India, you have substantial promoter holding, either more than 51% in most cases, or even if it is less than 51%, it is still substantive enough to give control to a identified Indian promoter. So so therefore, the acquisition of a control merely by mopping up shares by FPI is although a distinct theoretical possibility, but may not be a practical reality for the overwhelming majority of Indian companies. But in those companies where there is a widespread public float with the possibility of mopping up shares from the market, then you can definitely have a situation arising like this. And that, unfortunately, is a loophole that the government has not recognized in allowing FPI investments from China without approval, but restricting it for FDIs.
There's one more question which I'll put to Raj. Raj, the question is, and it's anonymous, a distinction has been made between funds being brought into India or used for global operations without bringing into India. Would you clarify, if the funds are not brought into India at all, how can that be an FDI triggering of these rules?
Yes, sure, of course, Shipri. I did expect this question on this, because especially when we covered it on the slide, I was expecting that somebody is going to ask this question as to, how would FDI norms get triggered if there is no FDI or fund flow into India. But again, if we go back to the intent of the press note, the intent of the press note is to regulate beneficial interest and beneficial ownership. So even in a case where funds are not eventually remitted to India, it is a secondary transaction or a primary transaction where there is fundraise at the offshore holdco level, but the monies don't come into India. There is effectively an increase in the beneficial ownership of the Indian entity by the acquirer. And because of that increase in the beneficial ownership of the acquirer, it would come within the purview of the press note. Again, I think here it is more about increasing the beneficial interest or the ownership in the underlying Indian entity rather than the actual fund flow into India.
Okay. Thank you so much, Raj. And with that, we've come to the end of our time for this webinar. Thank you so much for joining us and sending us your very, very interesting questions. Do feel free to reach out to any of us if you have more questions. I'm sorry that we can't possibly cover all the questions in this session because we've run out of time. So I would encourage anyone whose questions have not been answered to reach out to any of us for the answers. Our email address is there. Thank you again. Thank you, Rohitashwa, Lalit, and Raj, for your very valuable inputs. And thank you, the IT team, JSA IT team. You've been a tremendous support as always. Thanks.
Thank you. Thank you, everybody.
Thanks, everyone. Thank you.